All right, are you seeing my screen? Very good. Well, good morning, everyone. I appreciate the chance to present with you this morning. I'm going to be providing the legal context or background as an initial matter and then participating in the conversation as we go, talking about the public policy pieces as well. And I'm going to talk about the case of Martin versus City of Boise, which is the Ninth Circuit decision that is controlling law for a lot of these issues. I'll then be talking about some of the cases that have come out since, and then some of the cutting edge legal issues that are going on right now on this issue of public agencies' abilities to relocate or preclude camping or unhoused people from being on public land. As I start this presentation, I do want to say that you need to remember the context from which I'm presenting. I'm not here telling you that you should be excluding people from public land. I'm providing the legal context for what the law says on that topic. As a human, I actually think we have an obligation to help solve this problem. It is not a problem that was created just by the people who happen to be homeless at this time. But I will also note, as a public agency attorney, the majority of my clients are special purpose. They do not necessarily have the authority to do anything in this space, and many of them do not have budget that they can expend in this space. And so please, as you hear my comments, don't think that I am advocating legal solutions to these problems. I'm actually trying to just provide one piece of the background knowledge we all need to try to come up with solutions that work. So let's start with the case of Martin versus City of Boise. It came out in 2018, obviously from Idaho. And the case was a matter in which there were challenges to ordinances that the City of Boise had adopted. And as the court put it, and excuse all the words, but I'm a lawyer and we focus on words, very few pictures, unfortunately. What the court said is we consider whether the Eighth Amendment prohibition on cruel and unusual punishment bars the city from prosecuting people criminally for sleeping outside on public property when those people have no home or other shelter to go to. And their conclusion is that the Eighth Amendment to the US Constitution does apply, and that so long as there's a greater number of homeless individuals in a jurisdiction than the number of available beds, the jurisdiction cannot prosecute homeless individuals for involuntarily sitting, lying, and sleeping in public. And I will note preliminarily, and Helene will probably talk about this more later, I'm unaware of any jurisdiction struggling with these issues where there are more shelter beds than there are individuals. So we are inevitably in the case where we're having to deal with the Boise test. Now, in Boise, what the actions were was, one, it was illegal to use any of the streets, sidewalks, parks, or public places as camping places at any time, and also occupying, lodging, or sleeping in any building, structure, or public place without the permission of the owner was criminally prosecutable, okay? Now, what the court said, though, is that while they found that the ordinance was illegal, they were in no way dictating to the city that it had to provide shelter. And that's disappointing to many advocates because they want cities to have that obligation. And the court said, no, that's not something we can do. But the important part really for many of you who are out there today is the footnote. And footnote 8 is dicta. Dicta means it's something the court says that's advisory, but it's not binding. And what the court said is we do not suggest that a jurisdiction with insufficient shelter can never criminalize the act of sleeping outside. An ordinance prohibiting sitting, lying, or sleeping at particular times or particular locations might be allowed, and also ordinances bearing the obstruction of public rights of way or erection of certain structures might be allowed. So the court was saying, Boise, you went too far, but that one, it doesn't mean Boise has to solve the problem, and it also doesn't mean Boise can't do anything. And so following the City of Boise, we had a series of cases that came out. I'm going to focus on 3 of them. And these are the cases that actually have set out what the rules are as we get into more detail. So first, in Frank versus City of St. Louis, the context was the city sought to close an unauthorized encampment due to COVID risk. And Ms. Frank came forward and said to the court, I want to stop the city from closing. This is where I'm living now. And what the court said is, no, we're not going to stop the city from closing this particular encampment. The court said that at most the city is criminalizing sleeping in public in a particular location, And also, they have a good reason. There's a very high COVID risk, and COVID is spreading there. It was also not clear that the city's action was criminalizing homelessness at all, that what they were doing was they were making people leave the particular area. There were no actions of arresting individuals. They were just clearing the area. And so it seemed to be more of a civil action than a criminal action. And the notice and order that had been issued by the city clearly stated that there were alternative housings available. Now, whether there were enough or not is a different issue, but again, they were only clearing one particular encampment area, and so it seems like there were enough beds. And so in this particular case, the court found that Boise did not control, that Boise did not limit the actions of the city of St. Louis. So let's go to the second case now, and this is Gomes versus Kauai, coming out of Hawaii. And here, Gomes sued the county of Kauai, which was challenged, which had an illegal camping ordinance, and said you couldn't construct any structures in a public park. And in this particular case, the plaintiff said that the county's capacity was 19 people in a homeless shelter, but there were over 500 people registered as homeless, again, showing the insufficiency of beds. And defendants filed a motion to dismiss saying, we don't think there's a claim here. The court agreed. What the court found is that plaintiffs were cited for sleeping at a public park, not on public property generally. In other words, the ordinance precluded sleeping at a particular location, not at all locations, and therefore it was within the dicta of footnote 8 of the Boise case, finding that this wasn't an impermissible prohibition. The third case I want to talk about briefly is City of Eugene versus Adams. This is 2021, and this was an appeal of a criminal conviction for trespass. Defendant had been found sleeping in front of an elevator to a private building, blocking access for employees. And what the court found here is that nothing in the Boise case, nothing in Martin, supports the extension of the rationale from that case into private property. Recall that Boise was about public property. And the court here said the Eighth Amendment is really only dealing with public property issues. And so the court concluded that neither the Eighth Amendment nor Article 1, Section 16 prohibited enforcement of criminal trespass laws against the homeless when dealing with private property. So those are the three cases I wanted to talk about. And I want to now summarize what those rules are from those cases. So one is it only applies to public property, not private property. The prohibitions of Boise only apply to public property. And the relevance of that is whether you think this is good public policy or bad public policy. I'm aware of at least one city that leased public property to a private organization, and then the private organization was able to exclude homeless from that area because it was no longer considered public property. So that's one particular nuance that's coming out of the case. Another is that the Boise restrictions don't apply if there are no criminal charges possible. In other words, if it's only a civil context. And I'll talk about that a little bit more in a new case that recently came out. Third, it doesn't apply if you're not prohibiting access to all public property. So we have the Gomes case out of Kauai where it was only a public park. We had the St. Louis case where it was only one particular encampment. And in those cases, the court said you're not prohibiting access to all public property, only some public property. And therefore, in those cases, there was not a restriction. It also doesn't seem to apply to temporary prohibitions to achieve public policies like cleaning or trying to limit the spread of COVID. Now, there are a few actions that have occurred since then that I don't think quite rise to the level of the three I've summarized, but I at least want to note. So first is Sacramento Homeless Union versus Sacramento. Here in the Sacramento area, as many of you know, we have very warm summers. In fact, this summer, I think we had 10 days that were over 110 degrees. And there was an action brought by the Sacramento Homeless Union against the city to stop any clearing off of public property. And where people were cleared off public property, they were moved into a temporary encampment that had been constructed by the city. That encampment was constructed into a parking lot area with no shade. And the argument was you were moving people into very hot areas on some of the hottest days of the year. And so what the court ultimately found is that the moving of people was prohibited, but I want to highlight that last sentence for you. The court found that Martin had no bearing on the relief being sought. In other words, it was just common sense. You're not going to be allowed to clear homeless people and put them into a really hot area on really hot days. And the Martin restrictions weren't relevant at all, according to that court. The second thing I'd like to highlight is the Tennessee approach, and thanks to Helene for making me aware of this. So this year, the Tennessee legislature actually passed SB 1610, which expanded the Equal Access to Public Property Act of 2012 to include all city and county property. And what it now says is that camping on any public property not designated for camping is a Class E felony in Tennessee. So this is a very different approach to some of the others that we've talked about thus far, where the public agencies were trying to narrow where homeless might be. Here, Tennessee is saying, we're just going to make everything off limits. We're going to make it clearly, directly opposite of the holding in Boise. Now, for those of you who don't follow the federal courts, the federal court system is divided up into different circuits, and the Ninth Circuit Court of Appeal, where Boise came out of, is basically the Western US. It's about 1/6 of the population of the US, although Helene tells me it's actually the largest area where we deal with homeless populations in our country. Tennessee is not in the Ninth Circuit Court of Appeal, and so if the Tennessee statute is challenged and makes it up, it could ultimately lead to some sort of a challenge at the US Supreme Court, because it really directly conflicts with the holding in Boise. And so we'll have to track that and see if the two ultimately do come together at the US Supreme Court and we get some clarity at national level. The third and final update I wanted to provide to you is on the case of Blake versus City of Grants Pass. And again, thanks to Helene for making me aware of this. I think when you're a national coordinator on these issues, you hear about these things before anyone else does. So the City of Grants Pass case is an interesting one. It's quite long. I don't actually think it's worth the time for most people to read it. The important thing about it is the prohibitions at action in that case actually pre-existed Boise. All that case was doing was litigating the old prohibitions in light of the law in Boise. And so it doesn't really give us much new law. It does help us with a little bit of things, though. The court was dealing with the fact that there were anti-sleeping ordinances and anti-camping ordinances, which punished with civil fines that could ripen into a criminal punishment. And it didn't prohibit sleeping in public. It only prohibited sleeping in public with shelter or bedding. So if it was 30 degrees out and you wanted to lay down in a park with no blanket on you, you were not in violation of the statute. But if you wanted to have any sort of blanket on you because it was 30 degrees, you now were in violation of the statute. And the court said that the decision reached beyond Martin only slightly, and they had three little areas that they noted. First is class certification is not categorically impermissible, or to put that into English, it is possible that the homeless can form a class action against a public agency on these issues. Really interesting more to the lawyers than the public policy makers, but it is an important point on how these cases may be litigated. Secondly, sleeping in the context of Martin includes sleeping with rudimentary forms of protection from the elements, meaning the fact that they changed their sleeping ordinance to say you can sleep but not with bedding doesn't get you around the Martin holding. And then thirdly, Martin does apply even where there are civil citations like here, where civil and criminal punishments are closely intertwined. In the Blake case, if you had two civil penalties assessed against you, it could then ripen into a criminal assessment. And what the court said is, yes, that's not identical to Boise, where you immediately go criminal, but the fact that it can ripen from civil to criminal basically means we're going to say it applies. So that's really what I have on the legal background. I hope that provides some context on what public agencies are and are not permitted to do. We're now going to move into what some of the opportunities are to try to solve the problem.